Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Rogers versus Board of Road Commissioners for Kent County. This case was heard in the Supreme Court of Michigan in the year 1947. Let's go ahead and jump into the facts of the case. The suit was brought by the wife of Theodore Rogers, who was deceased when the suit was brought. Theodore Rogers and his wife owned a piece of property. Alongside it was a road. The commissioners of Kent County wanted to place a snow fence alongside that road. So the Rogers gave them conditional use, allowed them to do that. They said you can place a snow fence, but it needs to be removed completely every summer so that we're able to, access our property and do what we'd like to here. It looked like the fence was removed, and Theodore Rogers began to mow his lawn. So he was mowing his lawn, and he was on a heavy piece of machinery. When he was on this heavy piece of machinery, it struck a piece of wrought iron that was in the ground still, but was hidden by the grass because the grass was quite tall. This threw him from his machine and threw him to the ground, and he ultimately suffered and died. His wife sued, arguing that because the commissioners for Kent County left behind that piece of the fence and it ultimately led to the death of her husband, that they were liable for trespass. Trespass to land, in this case, was the cause of action that the Rogers raised against the Kent County commissioners. So the issue before the court was whether leaving behind a piece of property, chattel, amounts to trespass on land if that property is left behind without the consent of the owner. The ruling, in this case, the court decides ultimately that what the Board of the Road Commissioners for Kent County did by leaving behind, and when they failed to completely remove the fence, they were trespassing on the land of the Rogers. And so they held that because that piece of fence was left behind and led to the death, it was ultimately a trespass to property, and that intentional tort gives way to strict liability. And the court's decision, I just want to read briefly. They cite the restatement where they say, failure to remove a thing on the land pursuant to a license or other privilege, a trespass actionable under the rule, may be committed by the continued presence on the land of a structure, chattel, or other thing, which the actor or his predecessor in legal interests therein has placed thereon. So because they had a contract that was brief and it had terminated each spring when the sun came out, they needed to remove that fence, and that conditional use had ended for the Kent County commissioners. The court ruled in favor of the Rogers family. So that's the ruling. Let's go ahead and jump into some scenarios and some ex ante implications of the case. First one I want to jump into is, say you are renting a house from someone, and when you leave the house, you leave behind your dog. This dog is a German Shepherd. It's ferocious, and it likes to attack whenever someone comes in. And so when the landowner comes in to survey their property and begin to turn it over for the next customer, for their next tenant, they are attacked by your dog. Are you held liable for trespass? Probably among other things, but are you held liable for trespass? Underneath this ruling, I think you could argue very reasonably that leaving the dog behind, leaving that chattel behind, amounted to a trespass. So even another case that's not quite as intuitive. You're renting an apartment, and when you vacate the apartment, you leave behind a pot. You leave behind just, a nice pot. The person that moves into there next goes ahead and takes that pot and begins using it and burns themselves on the pot that you left behind. So they want to sue for trespass. You think they could sue for trespass in that case? I think it's a little bit less intuitive, a little bit more of a gray area. I don't know how sympathetic the person would be to trespass in that scenario, even if there was damage, because there's likely some type of contributory negligence on the part of the piece of cookware's user. So something to think about a little bit more there. That's probably as gray as I can get with this, is it leaving behind a pot and then someone burns themselves on that pot. Do we really want to amount that to trespass to land when it was really just a bit of negligence in leaving behind the pot on the person's property? So thanks so much for watching. Hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. I hope you have a nice rest of your day. Bye.